May it please the Court. I'm Mark Stopa, counsel for the appellants. I would request 5 minutes for rebuttal.
All right.
This is an appeal of a final judgment of foreclosure entered after a summary judgment. I submit that reversal is appropriate and required for a few different reasons. I want to start with Rule 1.510C. That rule, the summary judgment rule, very clearly provides that a summary judgment motion, quote, shall state with particularity the grounds upon which it is based and the substantial matters of law to be argued. Now, this court in Amstone in 2016 interpreted that rule as requiring that when a movement for summary judgment in a foreclosure case, when a plaintiff in a foreclosure case moves for summary judgment, that it has to not only conclusively disprove all of the defendant's affirmative defenses, which is longstanding law in any context, but certainly has to, at minimum, mention the affirmative defenses within the written motion itself. This court followed a 4th District decision in Alejandre that ruled similarly. If Your Honors look at the summary judgment motion at bar in this case, it makes no mention of any of our affirmative defenses at all. They were completely ignored, not mentioned in any way. The Amstone decision is on all fours in that regard and requires reversal. Now, to illustrate just how clear and how strict of a...
Maybe while we're here, though, it would be a good idea to talk about the lack of transcript at the hearing.
Sure.
Because while the papers may not have indicated any addressing of these affirmative defenses, we don't really know what happened at the hearing, do we?
Well, I agree with that, but Your Honors, this is de novo review, and I cited as the first issue in the reply brief 3 DCA decisions which make clear that you don't need a transcript from a summary judgment hearing because it is de novo review: Shahar, Gonzalez, and Mansfield. The cases that my opponent cites on their preservation argument all emanate from trials or evidentiary hearings where there were fact findings made by the lower tribunal.
I'm a practical guy, and I think to myself, having presided at a number of these hearings when I was a trial judge, things are said at these hearings, and while the motions and the supporting affidavits address the substantial matters, other things are said at these hearings, and there may have been some conversation about these affirmative defenses, and without a transcript, we don't know that.
Well, I agree that you don't know what happened without a transcript, but respectfully, that's just not the law. There aren't any cases that say that errors at summary judgment hearings are not preserved because there's not a transcript. In fact, the courts are all very clear in ruling that the absence of a transcript is impertinent when the transcript pertains to a summary judgment hearing and the appeal is from a summary judgment ruling, because it's de novo review. Your review is based on the papers, so you don't need a transcript in order to adjudicate this appeal.
Then why do we have a hearing? Why don't we just look at the papers and everybody stay home like you did that day?
Well, Judge, obviously staying home that day was not the ideal fact pattern, but the law is what it provides in that regard. And I understand the question, but I would submit, frankly, that's above my pay grade. I don't get to create what the law is. I tell Your Honors what it is and argue what it is, and I think it's clear in the cases that I've cited, you don't need a transcript from a summary judgment hearing. I also submit that to the extent that there was no initial appearance, that was cured by the motion for rehearing, and there is a transcript of that where we pointed out all these issues, and the lower court had an opportunity to fix it and to conclude, yeah, there was no standing here. Yeah, they didn't conclusively disprove these affirmative defenses, and for whatever reason, it still did it. Timely motion for rehearing that points out all of the issues, all of the reasons that the summary judgment shouldn't have been granted in the first place. So
the motion for rehearing seemed to be more in the nature of not about the substantive matters, but more in the nature of why you weren't there.
Well, I think that it did both. I think that it clearly did both. I think that the hearing transcript from that reflects that both matters were argued. We argued the affirmative defenses were not rebutted or conclusively disproven. We argued the standing issue. Your Honors, there's no way for this court to rule in my opponent's favor on the preservation issue without conflicting with its own decisions and without certifying conflict with other DCAs as well. Your Honor, as you sit here now, might not like that result, and frankly, I've been on the other side of this, and I can see the other side of it too, but the cases are just legion and very clear that you just don't need a transcript from a summary judgment hearing in order to preserve the errors. And so I could perhaps understand it a little better if nothing had been done at the rehearing posture or something of that ilk, but, you know, this is a record that's clear. I mean, Judge, we're talking about a motion, summary judgment motion in a 7-year-old case that was purely a cut and paste, that made no mention of our affirmative defenses at all. And how strictly did this court interpret that rule, that the affirmative defenses have to be in the motion? In Amstone, if you look closely at that decision, in that case, this court reversed because the motion didn't address paragraph 22, 559715, or a cost bond, even though the plaintiff in that case actually had filed an affidavit that showed that the 22 letter was sent, because that affidavit and issue wasn't mentioned in the motion itself. These issues all have to be in the motion. The motion was a dead motion walking the instant that it was filed. That never should have been granted, and then the rehearing on it should have been granted. And frankly, this is an issue that, especially after Amstone, I submit there should have been a confession of error on. This is just clear law on that issue. This court said that it reversed the summary judgment, quote, because the motion, quote, did not address the affirmative defenses in its motion for summary judgment. And then and that cites the Alejandre decision, which rules the exact same way. So that's why I submit the law is so clear in that regard that that's why my opponent came back in the answer brief to say, well, the affirmative defenses were legally insufficient, so you can just affirm. But that's why I came back in the reply brief and said, you don't get to argue that for the first time in your answer brief. You don't get to argue that for the first time on appeal. For instance, in Elkins, the 4th DCA said, and I quote, appellee's challenges on appeal to the legal sufficiency of the defenses were never made to the trial court, and we cannot consider them for the first time on appeal.
In Amstone, the counsel for the borrower was present and raised the issue of the failure of the bank to address the affirmative defenses, so it was preserved in that way.
Well,
that didn't happen in this case.
Judge, I understand, and that's a distinction without a difference, because I respectfully submit you just can't get around all of the cases that show that you just don't have to have a transcript in order to preserve the issues. And then it certainly was excusable neglect, which we laid out in a verified motion for rehearing under penalty of perjury, explaining that I understand, but it shouldn't have been, and that's one of the reasons that we're here. It shouldn't have been. I mean, this is an issue. This is a case that should have been adjudicated on the merits. We shouldn't have had summary judgment entered against us when there was excusable neglect with respect to that initial hearing. And so we came back at the motion for rehearing and said, look, here's all the reasons why this motion, why there are facts in dispute, and why we weren't there at the initial hearing. Not attending it, we don't adjudicate cases on gotchas, especially when there was excusable neglect and especially when there were facts in dispute. We have numerous affirmative defenses like waiver, estoppel, unclean hands, set-off defenses.
Let me ask you about one of your defenses. Let me ask you about standing, which you raised in your third affirmative defense. With regard to the issue of city mortgages standing when the case was filed initially, do you concede that they established standing for purposes of summary judgment?
I think that city mortgage showed that it had standing when the suit was filed based on the affidavit that it filed on the lost note at summary judgment.
How about the standing of Penny Mac?
Penny Mac.
What's your position on that?
Penny Mac, absolutely not, and that's not even a close call, because there was no summary judgment evidence at all to show that Penny Mac had standing at the time that the final judgment was entered. And I think as you look at the briefs and the way that the arguments unfold in that regard, it's very clear that Penny Mac didn't. There's no affidavit. The note is endorsed. First, it's a lost note. It was endorsed not in blank, but to city mortgage. So the obvious question becomes, how does Penny Mac have standing? And I would encourage your honors to ask that question to my opponent. How does Penny Mac have standing? They weren't the holder. It was a lost note claim. They weren't the owner. There was no purchase and assumption agreement or anything like that. The assignment of mortgage that my opponent relies on in the answer brief was only conveyed the note, only conveyed the mortgage, not the note. And there's a long line of cases, including from this court, that say an assignment of mortgage without an assignment of the note is a nullity. Caballero and Gouy, I pronounce it Gouy, G-E-W-E-Y-E, from this court. I'm sorry?
G-Y.
G-Y?
G-Y.
the GY, maybe I'll start calling it that from now on. But anyway, this court has two cases which are very clear that an assignment of mortgage without an assignment of the note is a nullity. The assignment that they rely upon makes no reference to the note at all. And in addition, the assignment was not authenticated or attached to an affidavit at all, so it's not summary judgment evidence as a matter of law. My opponent tries to get around that by arguing in a footnote that the court could have taken judicial notice of that without any legal citations at all. That's just so obviously wrong. You can't, if they wanted the assignment to be a basis for summary judgment, they needed to comply with 1.510, designate it as summary judgment evidence, authenticate it, and have it include the note. And none of that happened at all. So I think that the assignment is a non-starter. They're not the holder. They're not the owner. The assignment's a non-starter. So what does PennyMac then argue? They argue, well, we substituted, so therefore we have the standing of city mortgage. That's wrong as a matter of law. I cite your honors 3 cases in the briefs, Lamb, Creedon, and GY. 3 cases which all three of those cases, including 2 from this court, the initial plaintiff had standing, but after there was a substitution, the substituted plaintiff did not have standing as of the final judgment as a matter of law, and in all 3 cases, the courts reversed because of that. In Creedon and GY, both decisions reversed even though the initial plaintiff had standing because the current plaintiff didn't at the time of trial. And why is that? Because in GY, quote, an order of substitution does not create standing in a foreclosure action, end quote. So their argument there is a complete non-starter. And then what's the argument about PennyMac having standing as of the time? What's their other argument? Well, it's the servicer. They didn't plead that. They didn't argue that below. That's not in their written motion. So if that's the first time on appeal they're arguing that, it's contrary to law. It's clearly wrong. This court's St. Clair decision makes very clear that merely being the servicer doesn't create standing to foreclose. And that's especially the case when you have a lost note count. So what was PennyMac's standing to foreclose in a lost note case?
Was
Nothing.
PennyMac actually the servicer? Is there anything that establishes that?
There is no summary judgment evidence that establishes that, and that wasn't in the written motion as required by 1.510C. So there's no summary judgment evidence that establishes that, but even if there had been, they didn't argue that in the motion. They're arguing it for the first time on appeal, and it's wrong as a matter of law. Being the servicer does not convey standing, and it wasn't even pled. That wasn't even their pled theory of standing. I think if you look at even their pleading, their pled theory of standing is just unlike anything. I do these cases. I have a lot of them. I don't know that I've ever seen one like this. They don't allege owner. They don't allege holder. They say it was transferred. What does that even mean? How was it transferred? How did PennyMac have standing? There's no answer to that. It's very clear that without PennyMac having standing, that the final judgment of foreclosure has to be reversed. There were clearly factual issues in that regard. We had a standing affirmative defense. It's an element of their prima facie case. It was their burden to conclusively prove the issue. And it's very clear that they just didn't do it. So you have Amstone and Alejandre, and Your Honors, their motion is just a cut and paste form. That just doesn't do it. They don't get to argue the affirmative defenses are legally insufficient for the first time on appeal. The Elkins decision is squarely on point in that regard. They have no case law that they can cite or will cite that allows them to argue the legal sufficiency of defenses for the first time on appeal. And when we have some of the affirmative defenses, my client actually had prior versions of the answers had verified under oath. We verified affirmative defenses under oath that they certainly didn't disprove any of that. None of them were stricken. They didn't file any motions to strike or have any of those affirmative defenses stricken. So, frankly, there was a lot that I could argue in this case, but those 2 issues in particular, Amstone and the violation of 1.510C and failure to disprove the affirmative defenses or even mention them in the motion itself, along with the obvious lack of standing of PennyMac as of the time of the final judgment are both clearly issues which required that this final judgment be reversed and remanded to the lower court to conduct a trial. I understand Your Honor's preservation concerns, but you're simply not going to find a decision that says that not having a transcript from the summary judgment hearing where it's done over review somehow authorizes you to affirm when there were clearly facts in dispute. To rule that way, you would have to contravene your own decisions as well as other and certify conflict with other DCAs, and that respectfully just shouldn't happen. So I'm happy to answer any questions that Your Honors may have. Otherwise, I would save the rest of my time for rebuttal. Thank you.
All right, Mr. Stopa, you've got your 5 minutes for rebuttal, sir.
Thank you.
Good morning.
Good morning.
Mark Gottlieb on behalf of Appellee PennyMac Corp. The trial court in this case correctly granted summary judgment of foreclosure.
Your name again?
Mark Gottlieb
Oh, all right.
with Ackerman. Appellant is asking you to adopt a bright line rule under 1.510C that each and every affirmative defense, no matter how legally insufficient, no matter how meritless, and regardless of whether addressed at a hearing, has to be addressed in the written motion papers or you lose at summary judgment. That's a rule of law that you're being asked to establish in this case. The reason they're asking you to adopt that rule of law is because there's no transcript of what transpired at the hearing in this case. So without that, unless you adopt that rule of law, they lose, because there's no way for this court to know whether each and every affirmative defense was in fact addressed at the hearing and whether the legal insufficiency was addressed at the hearing. And as Your Honor pointed out, that's frequently what happens, because that's the way Florida practice typically works.
The difficulty in this case is not only is there no transcript, but the papers that the bank filed in support of its motion for summary judgment doesn't address any of this either.
Yes, clearly it doesn't.
So we have a complete void on both sides.
We concede that, but in the absence of a transcript, unless there's a rule that says you have to address it in papers, and a failure to address it in papers is dispositive, you cannot address it at a hearing, unless there's that rule.
Matters of law to be argued would seem to include your addressing the affirmative defenses.
Well, we would disagree that that's a reading of 1.510 and the provisions.
Are those not substantial matters of law?
No, not when they're facially and legally insufficient, and particularly in the context of foreclosure defense.
Great if you said just that.
I'm sorry?
Would have been great if you had said at least that.
Well, Your Honor, I think the court is cognizant of what happens in the context of foreclosure defense. You get very often 20-plus boilerplate, very often facially insufficient, non-prosecuted defenses. Each case boils down, at the end of the day, to standing and conditions precedent. Virtually every case comes down to that at the end of the day. Those are the substantial matters of law to be argued. The rule doesn't require every matter of law to be argued.
No, but the cases seem to indicate, particularly Amstone, want you to do that, want you to address them, want you to negate them.
As maybe a preferred practice, but not as a legal requirement. And Amstone does not...
Amstone reversed on that basis.
Amstone noted the fact, and obviously it's this court's decision, so I'm not telling this court what it ruled, but on its face, Amstone specifically notes the fact that there was a hearing and a transcript, and not only were the issues not addressed in the written papers, they weren't addressed at the hearing. And all of the other cases that address the issue either note the fact that there was a hearing and the issues weren't addressed at the hearing, or they rely on things that didn't have to be covered at the hearing. In other words, they're addressing where a summary judgment motion presents factual issues that need to be rebutted by affidavit. Those things have to be accomplished outside of a hearing.
Here's the difficulty with that position. Amstone cited Alejandro versus Deutsche Bank, a fourth DCA case, which specifically held that the bank moved for summary judgment, but in that motion failed to address affirmative defenses raised by the mortgagor. And because of that, it was reversed.
Alejandro doesn't note whether there was a hearing or not and whether there was a transcript of a hearing, and I don't think it purports to adopt a bright line rule. If the court's going to adopt that bright line rule, then we concede this motion didn't address it. We would urge the court not to.
Even if you're right that you don't have to negate the defenses in your summary judgment motion, don't you at least have to prove standing before you're entitled to foreclose?
Yes, absolutely. That's a prima facie element of the case.
Even on a default, don't you?
Absolutely. And we believe that standing was adequately established in this case.
All right, well, why don't you tell us about that?
Certainly. With respect to the issue of standing, importantly, they're not challenging the original plaintiff city mortgage, and they conceded it in their argument. The original plaintiff city mortgage is standing to proceed here as under the lost note statute. They're relying on this court's decisions in Creedon and July to say that a substituted plaintiff has to independently prove its own standing, regardless of whether there was an uncontested substitution motion that was granted, and regardless of whether it's clear that the original plaintiff had standing to commence the action. We believe that Jawai and Creedon are distinguishable in several important ways. Number one, and I think counsel noted this, standing in this case was pled in a different way. In each one of those cases, the substituted party sought to proceed as a holder, saying, I've got the note, I've got possession of it. And so they had to prove that allegation. That's the way they sought to proceed. In addition, in each one of those cases, the issue of substitution was actually contested or challenged. In this case, it was not contested or challenged. And lastly, unlike those cases, in this case, this was purely an in rem foreclosure. The bankruptcy, the borrower in this case had received a bankruptcy discharge. It's a matter of record. So no relief was being separately sought for a deficiency under the note. The only relief being sought was under the mortgage for foreclosure. And under those circumstances, we believe that this case is distinguishable in important ways from the second DCA's decisions in both Jawai and Creedon. But to the extent that this court is inclined or being asked to adopt a rule that says that a substituted party in every instance in the middle of litigation must independently and separately prove its standing, we'd ask the court to closely examine that issue because we believe it to be inconsistent with settled law both in this district and throughout the state of Florida.
Well, I mean, isn't that what we held in GY? I mean, that was very similar to this case, except we didn't have a loss note there. We had a note that was in the court file, so it really couldn't be endorsed at the time of the substitution. And here we have a loss note that wasn't subject to being transferred by an endorsement.
Right. So the only way for PennyMac to acquire the rights on a lost note was to acquire them from City Mortgage, which irrefutably had standing to prosecute this action. So City Mortgage, the party that everybody concedes had standing to prosecute, files a motion and says, we've transferred our rights to these guys, our rights to enforce the mortgage. And that's all the complaint alleges, that they received the right to enforce the mortgage from the original plaintiff to City Mortgage.
Right, the mortgage but not the note.
The mortgage but not the note. And I will say, listen.
And that was an unsworn motion, wasn't it?
That was an unsworn motion, yes. But, Your Honor, again, going back to what I've previously tried to argue, this notion that a substituted party has to independently prove standing needs to be re-examined to the extent that that's an across-the-board rule. And again, we believe that Jawai and Creedon are distinguishable. But if the court believes that they apply and the facts are here indistinguishable, then we submit that that rule needs to be examined. And here's why we believe it needs to be examined. The cases from which all the standing law emanates talk about standing at case inception. They don't talk about the need for a party to continually have to be able to prove its standing from case inception through the time of judgment. In fact, Florida law is exactly contrary to that. Rule 1.260 is crystal clear. A party that has standing at case inception, the real party in interest, if you transfer away all of your rights during the course of litigation, you can continue to prosecute that action through judgment. Even though clearly you don't have standing, the rule specifically says that you're allowed to do that. And this court and other courts have recognized and have followed and adopted that rule to say that the original party that they had standing transferred away all those rights can continue to prosecute an action to judgment. So the irony here is that had City Mortgage remained in, even though it admittedly had transferred away all its rights, and proceeded to judgment, and then just assigned its judgment or its bid to PennyMac, we wouldn't be here. Nobody would have an argument. City Mortgage didn't have to have standing all the way to judgment. But because they were forthright and filed a motion saying, hey, we've transferred and assigned our rights, here's a copy of a recorded assignment of mortgage, and that motion is granted without objection, now PennyMac is being treated as something different and being held to a whole higher and different standard.
Well, how is it difficult to put in some kind of evidence that you've actually transferred the note? I mean, what's hard about that?
I'm not, well, first of all, you can't transfer the note because the note itself has been lost. So delivery of the note and these other cases that deal with holder, physical possession was required. Here, you couldn't transfer physical possession because you don't have it.
I thought in GY Judge Black said something about that it could be done by an assignment.
Yeah, I mean,
By an assignment. And this is important as well, and I'd like to raise this point. And I understand there's case law out there that says an assignment of the note, of the mortgage without the note doesn't do anything for standing purposes. We fully understand that. None of those cases addressed, and we've addressed it in our brief, that there is a Florida statute here that is directly on point. 701.01. It's never been addressed in any of these cases. It's never been addressed by appellants in their brief. But it explicitly says that an assignment of a mortgage, irrespective of any assignment of a note, conveys with it all rights to prosecute a foreclosure that the assignor of that mortgage had, without regard to the assignment of the note. And in particular, we're talking about purely in rem relief, the prosecution of a foreclosure. Nobody's seeking separate relief under the note for a deficiency, just foreclosure in rem relief. That statute is squarely on point and is contrary to all this sort of conclusory law out there that says you gotta have an assignment of the note with the mortgage. You can't jibe those two things together. Florida legislature has spoken on this issue unequivocally.
If we were to agree with you that 701.01 controls and that would be sufficient to show standing, then wouldn't we still be bound by GY and other decisions and have to somehow recede from them?
Well, yes, I think you can recede from them. Courts recede from decisions all the time. I don't think 701.01 was presented as an argument in GY.
So is the basis of your argument here today that in order for you to prevail, we have to recede from these decisions?
No, the basis of my argument today is, number one, I believe that GY and Creedon are materially, factually distinguishable for the reasons that I've mentioned. But if the court disagrees and finds them to be on all fours factually, in terms of important facts, then our arguments are, number one, we believe that the law requiring substituted parties to independently provide standing is simply at odds with settled Florida law and should be revisited.
Well, the Florida law that you're talking about generally doesn't deal with commercial paper. Actually, I can't think of any case that does, but it talks about assignment of causes of action which do not include commercial paper.
Well, actually, Your Honor, there's a case called Brandenburg, which we've cited in our papers, which is out of the Fourth DCA, and it is fairly recent, that says that under 1.260, when a party who unequivocally has standing moves to substitute a party, the transferee, the 1.260 transferee acquires the standing of the original party pursuant to the rule, without regard to any separate proof of you transferred the note.
Is that a commercial paper case?
Yes, it's a mortgage foreclosure case. And that's Brandenburg.
Was there an assignment of a mortgage without a note in that case?
There's no reference to any assignments, period. They relied purely on the substitution, saying that under 1.260, a substitution from a party who originally had standing undisputed is enough to convey the standing of the transferor. And we believe that should be enough. But if the court doesn't believe that's enough, you had an assignment of mortgage of record here. And unlike the Jean-Jacques case that they cite, this assignment of mortgage wasn't incomplete. It wasn't unexecuted. It had all of the recording information on it.
How was the assignment of mortgage authenticated so that it could properly be considered as summary judgment evidence?
The argument that was made on appeal was that it wasn't attached to an affidavit. And assignments of mortgage that are a matter of record, and this one bore all the recording information right on its face, do not have to be authenticated by an affidavit. They are self-authenticating, matters of public record, and are routinely admitted without objection and without testimony of a party.
It wasn't even a certified copy. It was just a plain paper copy.
Correct. It was not a certified copy. But again, we believe that the record evidence, when the party who unequivocally has standing stands up in an uncontested substitution motion and says, we've conveyed our rights to prosecute this foreclosure to these folks over here, and they present the assignment of mortgage, and that motion is granted without objection, we submit that that law should be revisited, that the law that is evolved under 1.260 should be revisited, and this notion that a substituted party has to suddenly prove its standing afresh when the case law from which this all evolved dealt with standing at case inception should be revisited. But we think that this court can do it without having to revisit, because we believe those decisions in Jawai and Creedon are distinguishable. So just to summarize, We don't believe that there is a bright line rule that says each and every affirmative defense has to be addressed, no matter how legally insufficient, regardless of whether it might have been addressed at a hearing, has to be addressed in papers or you lose on a summary judgment. That is going to encourage and reward bad practice that already exists. If you think 20 affirmative defenses boilerplate is a lot, you make a ruling like that, we'll have 30 or 40, because God forbid you've missed one in your papers, you now no longer can obtain summary judgment if that's the rule. And these affirmative defenses are facially meritless. And they are often addressed just at hearings. And this court can't conclude that they weren't addressed because there is no transcript. And without that transcript, the trial court's ruling has to be presumed correct, and you have to presume that those issues were properly addressed. The only way they get around that is if you adopt that bright line rule that says have to address each and every defense in paper, no matter how deficient. And that has not, at least to date, not been a rule of law announced by any court, including this court in Amstone. So we would urge the court to affirm for those reasons.
All right, thank you, Mr. Gottlieb. Mr. Stopa, you've got 5 minutes left for rebuttal, sir.
Thank you, Your Honors. Judge Morris, I'd like to start by answering the question that you asked to my opponent, where you asked him, is this court's affirming predicated on receding from all of these prior decisions? The answer to that is clearly yes. They're first asking you to recede from your own decision in Amstone, where Amstone follows on Alejandre and creates a very clear rule following 1.510C that the written motion has to address the affirmative defenses. It's very clear precedent. And he has no case law to the contrary, but asks you just to recede from it. Why? Based on, well, these are foreclosure cases, and they assert a bunch of boilerplate defenses, and that's not fair.
What about the Brandenburg decision out of the court?
Brandenburg, he pulls, that's on the concept of substitution, and a totally different concept, and he pulls one sentence of dicta from there. You have two decisions from this court which make very clear that you have to prove standing in a foreclosure case at two different times, the inception and at time of final judgment. And when the party is not the same at the time of final judgment as it was at standing, then it's two different proofs. Now, my opponent argues, well, most of these cases deal with the concept of standing at the inception of the case, and that's how this all started. Most cases do deal with standing at the inception, because that, frankly, is the issue that's harder to prove. So that's what you have most of the appellate decisions on, because that's what's more commonly litigated. Because at trial, it's typically, well, you have a blank endorsed note, so that plaintiff at the time of trial or at the time of final judgment has standing. But that doesn't change the fact that the law is very clear that there has to be standing at both times, at the inception and at entry of final judgment. And my opponent is asking, Your Honors, to just ignore GY, ignore Creedon, certify conflict with Lamb, ignore all of the decisions which create that dichotomy. That can't and shouldn't happen. There's no precedent that he can cite that supports the proposition that simply because the original plaintiff had standing, that somehow means that the current plaintiff the plaintiff as of the time of final judgment has standing too. And that's what he wants you to accept. Ipso facto, the original plaintiff had standing, so ipso facto, the plaintiff as of the time of trial has standing. That's not the law. And it's directly contrary to Creedon and GY, and he has no cases to support that proposition. That's the Brandenburg case is one sentence of dicta that talks about the concepts of substitution in general. But this court has and all the DCAs have made clear, you have to prove it at both times. In GY, an order of substitution does not create standing in a foreclosure action. And so then what does he say? Well, he tries to emphasize this was an uncontested, unopposed substitution. Well, yeah, because judges sign off on that ex parte as a matter of course all the time. It's like leave to amend. Orders granting substitutions are granted all the time, routinely, as a matter of course. It's like leave to amend. I can't stop leave to amend. But what's the operative question? The operative question is, did the current plaintiff, Pennymack, prove its standing? He alleges, well, there was a transfer of rights. It didn't travel under a holder theory. There was a transfer of rights. Where's the summary judgment evidence that City Mortgage transferred its rights to Pennymack? Where's that summary judgment evidence? There's none. None. I think, I find it really troubling that my opponent continues to argue this assignment when it was not mentioned in the motion, it's not authenticated as the summary judgment rule requires, and as legions of cases make clear, including from this court, and it doesn't convey the note. And that's another thing that he's asking you to do. Well, overlook GY, overlook Caballero, two decisions from this court which expressly rule an assignment of mortgage without the note as a nullity. And you'd have to certify conflict with 7 or 8 4th District decisions and 3 or 4 out of the 5th. There's like 14 or 15 decisions that make clear an assignment of mortgage without an assignment of the note is a nullity. And he asks you to overlook all of that with no opposing case merely by citing this statute, which doesn't change the analysis. You're bound by all those decisions. Those decisions are binding and controlling. Now, I argued also that the allegation that they were the servicer didn't change anything, and I argued that they didn't have any summary judgment evidence of that. You heard no contrary case law to that, no contrary case law to St. Clair about how being a servicer doesn't create standing or anything like that. No argument at all. He just wants you to create this bright line rule that ipso facto the current plaintiff has standing because the prior one did, when there's no legal authority for that. It's just not the law in this context. And so I submit that it's clear that Your Honor should follow the decisions that exist from this court and the other DCAs, as I've argued and cited in the briefs, and rule that and reverse because PennyMac did not prove its standing as of the time of the entry of the final judgment, and that this court should reverse because the plaintiff did not conclusively disprove the affirmative defenses. Now, my opponent laments, well, you're going to...
You're out of time, so you need to wrap up.
So I submit that for those reasons, Your Honor should reverse the summary judgment of foreclosure in this case and a remand for a trial. Thank you very much.
Thank you both, gentlemen.